This segment is sponsored by Dennis Goins of DennisGoins.com. Hi, Lady Charmaine, and I'm back with financial advisor, Mr. Dennis Goins of Dennis Goins and Associates. How you doing today, Dennis?
I'm doing fine, Lady Charmaine. How are you?
Good. Now, I love this topic because people are trying to find out what is the best form of ownership for them. Now, reading this, I didn't even know there was even different types of home ownership. So can you explain that to us?
Thank you very much. Yeah, this is a critical topic, and I run a lot in this when my clients come into my office. And let me say, one of the things that wherever you live, it depends on the state, before you enact on any of this information, check with an attorney that specializes in real estate law in your state, and also check with your tax advisor. But one of the things is, what is the best form of property ownership for an individual? And this is usually buying a house. And there's basically three types of property ownership for the most part. And I'm going to focus mainly in the state of California. Of course, different states have different laws. Sole ownership is one. Joint tenancy is another one. And tenants in common is another one. And a community property state, such as California, is another one. And let's talk about each one of those. And each one of them have pros and cons. Now, the issue here is, depending on how you own the property, depends on what's going to happen upon your death or demise. So sole property ownership obviously is one individual involved. It's just one person. They own the property. Upon their death, they have the right to determine through a will or trust on who is the beneficiary. And the key point about sole ownership is, upon death, a person gets stepped up basis on the market value of that particular house. For example, if I buy a house and I buy it several years ago and it's worth $50,000, and when I die it's worth $1 million, the person that assuming I'm single, I give it to my kids. Upon my death, my kids stepped up basis. It's not the $50,000 that I bought it on; it's the $1 million that the house is valued at my death. Now that's important because the IRS needs to get their hands involved in what we call capital gains tax. And instead of me paying capital gains tax from them paying capital gains tax on the value difference between the $50,000 and $1 million, they don't have to pay any capital gains tax at death. In other words, they get that credit for stepped up basis, and that's very critical in that. So say if on my death the house is worth $1 million, they can sell it for $1 million and not have to pay any capital gains tax. That's very critical in sole ownership. It's what we call credit for stepped up basis. Next is joint tenancy. And joint tenancy is very, very important, and it's the question is survivorship rights. And say, for example, Lady Charmaine, you and I buy a house. We're not married. And say I die before you, upon my death, the house is transferred directly to you. That's what we call rights to survivorship. Mm-hmm. Does not require a will, does not require trust. It's what we call transfer by law. Upon my death, if I say together we buy a house and it's worth $100,000, it was $100,000 when we bought it, and then that means you own $50,000 in it, I own $50,000 in it. Upon my death, obviously you want the full value, you want the full ownership and control of that house. So upon my death, on joint tenancy, my ownership of that house is automatically transferred to you. Now, you have control of it, but again, there's a downside to joint tenancy with rights to survivorship. And say the house is worth $200,000, you only get credit for your basis. You do not get credit for my $50,000 and I pay. So obviously, you have to pay capital gains tax on the difference between what is the house value that when you sell it and what your basis is. Very critical. You got to control. You will obviously, upon my death, you want to have control of that house. You get that, but there's a cost to doing that, and that's where you have to pay capital gains, and that's when you don't get full credit for stepped up base. Now, that's very important because you want survivorship rights. And then third, the other one is tenants in common. Say, for example, me, you, and another person buy a house. We each would own a third of that, or whatever the divisible issue is. And then say one of us died. Well, each one of us has the right to decide who gets our share of the house. Well, the surviving people, the surviving partners, that could be a problem. And this happens a lot in businesses. If we have three people that basically own a business, own a house in this situation here, one of them dies, well, you have to be able to, you're now in business with the beneficiary of that particular house. So you don't have that right to survivorship. And the only way that you can get that is via a transfer of a document, transfer by contract with a will or trust or some type of agreement. That can be a problem for the surviving partners and surviving beneficiaries. So, again, you don't get stepped-up basis, and more importantly, you don't get a right to survivorship. The person that owns that share gets to determine who your new partner will be. And then finally, there's community property. And this, particularly in California, I find a lot of this for clients to come in, and that's one of the key questions I ask them when we start talking about their house. A lot of them, I ask them, well, how is the house titled? Of course, most of them have no idea. But in a community property state, then it may be community property, it may be joint tenancy with rights to survivorship. But in community property state, obviously, say hypothetically, you and I were married, and we buy a house, then half of that house is yours, and half of that house is mine, irrespective of who paid what. Okay, so for example, you hypothetically would have kids, and I hypothetically have kids. Upon my death on community property, I may decide to give the other half of the house to you, or I may decide to give it to my kids. A lot of people don't understand that. They assume that, well, the house automatically, like joint tenancy with rights to survivorship, goes to the surviving spouse. A lot of times it does. And I have a saying, marriage and relationships is about love, but divorce and breakup, it's about money. And so a lot of people are still married but are separated out there, and obviously that could be an issue upon the death of that person. And everything I'm talking about, obviously, you need to cover that with your attorney, but it's something that people don't realize until there's a demise. But, for example, I could decide I don't want to give my half of the house to you. I want to give it to my kids from a previous marriage. Well, you can't live in half a house. So, I mean, you might want to sell the house, but you got to negotiate with my kids. Hypothetically, they may not like you, and hypothetically, you might not like them, but that becomes a problem. So it depends on what you want to accomplish when you title your house. Whether it be joint tenancy with rights to survivorship, no issue. The house automatically goes to you, but you got to pay taxes because you don't get credit for stepped-up basis. In community property, both your share and my share is stepped up to the market value. So hypothetically, we buy that house and it's worth $200,000. Your new basis, your adjusted basis, is $200,000. A lot of people have no idea what we're talking about and about this until the person dies. They try to sell the house. The house they did not. The surviving spouse did not transfer it by will or trust or whatever to the surviving spouse, and you have a situation. If it's joint tenancy and rights to survivorship, of course, you got the ownership of the house, but you got to pay taxes when you sell it. So it depends on what your objectives are. It depends on what your needs are as far as how you title the property. But each one of those has pros and cons. And I'm finding that a lot of people out there have no clue about the pros and cons of how they title their house. A lot of times they leave it up to the real estate agent or whatever to title it and set it up, and they just sign it and don't really know the pros and cons about joint tenancy and or community property. And that becomes a problem, and that's something that, again, you're not going to see it on the billboard out there anywhere. You'll know about it when a person has a death or something involved, but it's important information on how you title the property, the pros and cons. And so, in finality, I'm suggesting that people check on that. check and see how your house is titled. Check and see if that's what you want to have happen. Check and see to make sure that you and your spouse is cool, and of course, upon death, that you're going to make sure that you get that control of the house, or make up some other arrangement. But at least you don't want to be surprised in that situation.
It's so funny that you say that, because there's so much that goes into it. Like you say, we marry for what? Love and companionship, and then divorce is about money. And it is so true. And when you start dividing property and what belongs to you, love is out the window. What can I get out of this? And when you mention about when a spouse dies, you never think about their children as well, because they could be fighting over, different property, as you hear with a lot of celebrities who have passed away, and their kids and their spouse is fighting. But those are things that you really don't think about. So if they wanted to... Go ahead.
Yeah, well, and I hate to interrupt you. That's very, very critical. One of the prominent celebrities in the Bay Area that's passed away, and he had a trust and all that set up. The family and the kids are arguing about who gets the bicycle.
He say, "Who gets the? Are you kidding me?
Who gets the bicycle?" I mean, it's gotten that deep. So, that you got to know. And the reason, and I usually bring this up with my clients, you need to at least know what you're signing and what you're getting into, and understanding the ramifications of both. And if you own a small business, it's even more of a detriment, because you're really in a marriage when you have a partnership in a small business. And there's a lot of spouses that don't like the partners in their company. So if that person dies, guess who you're in business with? You're in that spouse that doesn't like you, and you don't like them. And that becomes, it's just like one of the TV shows. I mean, you have a problem in managing your business going forward, because upon your death, that partnership is over, and you have to be able to have an agreement or whatever to work it out and buy that surviving spouse out. So you got to plan for that.
It's funny that you mentioned that when you was like, yeah, it is a business. You don't really think about it, but paying bills, what's yours is theirs. And you are so right. If you look at it like that, then I think you might be more careful on who you might be marrying.
Well, you got to do that anyway, particularly if that definitely, you got, like I said, it's all about love, but, things can go 180 real quick. So, but at least you need to know and put it on the table. I mean, there's a lot of, I'll joke aside, there's a lot of blended families out there now.
Mm-hmm.
And you want to make sure that it's fair distribution of your assets. And it's important to sit down and talk about and discuss about, what is your estate plan? I mean, obviously you don't want, most spouses don't want their surviving spouse to be homeless, so to speak. They're not necessarily homeless, but basically can't sell the property. They want them to, come on, you to have the house and whatever. But if the documents are not set up for that and or not available, then they can have some issues there. You don't want to have to go through that. You want to plan and understand that. And more importantly, a lot of people that are separated and the divorce is not final, there could be some changes. A lot of people get with an attorney and change, their wills and trusts and whatever while the separation's going on, because they don't necessarily want that spouse, surviving ex-spouse, to get, more than their half. So you got to look at that, and I advise to talk to an attorney and definitely a tax accountant. And we kind of screen it when clients come in and we ask them that question and they don't know. And, hey, did they know this? And I didn't know this. And that's important for them to deal with it.
And I think all this is really good to share, if you even shared that information, because I'm sure there's a lot of people who didn't realize that. You marry somebody and they have kids. And for me, a light bulb just went off. It's like, that is so true. You don't think about that. So I think that is so good. So if someone wanted to talk to you more about this, how can they reach you?
They can reach me on my website at www.dennisgoins.com. My email address is dennis@dennisgoins.com. And they can reach me on LinkedIn at Dennis Goins and Associates. And I have a Facebook page, Dennis Goins and Associates.
Wonderful. And Dennis Goins is going to be one of our speakers at our 2015 Success Shop Series, taking place on next Saturday, September the 26th in Elk Grove, California at the Hilton Garden Inn. To get your tickets, just go to successhopseries.eventbrite.com and get your tickets right there. And thank you so much, Dennis, for sharing that information with us. It was very valuable.
Thanks very much. I look forward to seeing you next week.
Thank you for listening. If you would like to learn more about financial investments, contact Dennis Goins at dennisgoins.com.